How important, is it for information shared during the visit to match what's the original H-1B petition, and what happens if there's a mismatch?
So it's important. These are some of the do's and don'ts for FDNS site visit. Um, in order to, first of all, avoid a mismatch, you have to make sure that a copy of the entire petition is with your client, right? If you're an attorney, and that representative, if you're the employer, the representative who signed the I-129 petition should be given a copy of the entire petition and go through it. They should be at all given points of time be aware of what they're signing and what is in the petition. So if the representative lacks personal knowledge of any material fact, the employer should insist that that information be given to them, and so that it's accurate. If there is a site visit, they have to provide accurate information to the FDNS officer. If upon looking at the petition they find that there, or maybe the attorney did, or maybe the representative, or maybe the employer saw some information in the petition that was incorrect, then it is important that you file an amended petition in order to correct the record. So this will help if there is an FDNS site visit to ensure that there's always correct information given to them, and that you are um, paying the correct salary as per the LCA, that the work location is correct as per the LCA, and then if there's a site visit, you're not surprised unpleasantly that the FDNS officer discovers that the I-129 petition had a different work location and the beneficiary is actually working at a different location. So it's important that um, you know you do a proper audit of all the documentation on a regular basis, maybe a monthly basis, to make sure that nothing has changed after the filing of the petition for all your cases. Please be aware the most common problem that I see in an FDNS visit is the beneficiary is working from home, the beneficiary moves their home address, they don't notify anyone, the employer does not know, the FDNS officer goes to the old home address and doesn't find anyone there and issues a negative report to USCIS, and then USCIS then sends an intent to revoke. This is a very common scenario, so you have to make sure you tell your employees that they notify you. Maybe they don't think it's important to notify you, but it's important because that's the work location, especially if that's the work location. It's important that they notify you because an amended petition might be required, and ULCA, a different wage might be required. So
And I think it's, yeah,
after
sorry.
the fact, then if you find that, back to your question, that there is some mismatch, then that is a problem, because after the fact there's not much that can be done other than informing the FDNS officer that it was an error and you are taking immediate steps to correct that error. Immigration laws can be complex, so if you need any kind of legal advice, please reach out to me, Prashanthi at readyesq.com, or you can also call 212 354 1010. Keep watching. Thank you.